Today, we're discussing a recent book called Booze, Cigarettes, and Constitutional Dust-Ups. The book examines interprovincial free trade in Canada and why there are so many restrictions on moving goods between provinces within the same country. The book reviews legal cases, including cases that the charity I work for, the Canadian Constitution Foundation, have worked on. The book also considers the constitutional framework for interprovincial free trade and looks at how freer trade within Canada could be achieved. The book was the winner of the 2023 Donner Prize, a prestigious award for writing in Canadian public policy. I was honored to attend this award ceremony where I got to see the author, Ryan Manucha, win for his excellent book. Ryan, welcome to the show. Let me start by congratulating you on a wonderful book and for winning the Donner Prize. Before we get into the book, how did you feel about winning the award?
It was nice to be here. It was a complete honor, complete surprise. The slate of final candidates, just incredibly impressive individuals with incredibly important work. So, complete honor.
So let's talk about the book. You start the book with the story of Mr. Como, a retiree from rural New Brunswick who crossed the border into Quebec to pick up some beer, which is sold in Quebec at a lower price. And that trip led him all the way to the Supreme Court. Tell me about that case and the role that the case plays in Canada's history of internal free trade.
Absolutely. A fascinating case where, yes, Mr. Comeau came back into New Brunswick with this trunk full of beer. He did this trip, a couple times a year. It was cheaper in Quebec. So why not, especially if you've got the capacity. So, but he broke a law, which was the limit on the amount of beer or alcohol a New Brunswicker can bring back into the province from another province. And that was what he got caught for by the RCMP. They trailed him and pulled him over, gave him a fine, took his alcohol, took him to the Supreme Court, where he and his legal counsel essentially point to Section 121 of the Canadian Constitution, which is what we call the Free Trade Clause, which says, if you were to look at it very literally, all articles of manufacture, I'm paraphrasing, of manufacture should be admitted free to each of the provinces. And so Mr. Comeau's argument was, hey, the Constitution seems to protect what I just did. How can it be the case that I broke a law?
Well, the Supreme Court found that the provinces were entitled to restrict this good under sort of a barrier because they said they're entitled to regulate alcohol for public health reasons, right? And it's this very restrictive reading of the literal words of Section 121 of the Constitution. But do you think there's obviously a lot leading up to that interpretation, a lot of case law that led to that result. But in short, do you think the court got it wrong in the Como case by finding that this limit on bringing alcohol across the border was not a trade barrier?
That's a good question. And to be clear, Mr. Comeau wasn't necessarily arguing, Comeau and his legal counsel, for absolute unfettered free trade. But I think many Canadians saw the case about whether or not there is absolute unfettered free trade. And on that point, the Supreme Court, I believe, got it right, that there shouldn't be, it shouldn't be the case that we have complete trade liberalization. There's zero possibility for barriers, and any form of a barrier is unconstitutional. That would lead us into some tricky territory where, as you say, if New Brunswick sincerely believes that it is best positioned to guard against overconsumption of alcohol or consumption of alcohol by minors because of the regime and the infrastructure they've set in place, perhaps we should be a Canada that accepts that sort of regional difference and regional perspective. But I think where we all really have troubles with is when the law, and one interpretation of why New Brunswick was protected was for perhaps a public policy, public health argument. But what if it was just purely protecting local interests, tax revenue source? That's when I think it's possible to be a bit more cynical about the purpose behind a law that introduces a trade barrier. And I think that's what we should be more concerned about from the perspective of the judicial test and what we are as Canadians.
And certainly there have been barriers that some provinces have put in place saying that this is to protect trade revenue, and that doesn't, or is to protect tax revenue, and that's a valid public purpose. It isn't a trade barrier. It's a bit of an absurd argument, and I think that the the courts have rejected those particular arguments, but we'll talk about that in a little bit. Right now, we've got to go to commercial break, so we will be right back.